Welcome to You and the Law. My name is Steve Cilente.
And I'm Bob Lally.
Bob, today what I want to talk about is our notaries. We see them in everyday life. I'm sure that you've been before a notary public, signed documents. But do you ever think about what is their actual function?
No, it's sometimes, even as an attorney, you say, oh, you got to get that notarized in a notary public. I mean, how does a person actually get that, and what is their real function? And because I know sometimes things are done in a declaration, but it's different than something that has to be notarized.
There's a lot of misconception about what notaries are, what they do and can't do. Now, we're not going to be able to talk about everything, what goes into being a notary, other than that they've got to go through classes, they've got to take a test, and they have a commission for 4 years. We're going to talk about it in general, but hopefully by the end of today's show, you'll have a better idea of what a notary is and what they're for.
I have a question already.
What's that?
What's a commission?
That's the piece of paper that the Secretary of State issues that says that they can be a notary public. It's like a license. Okay, like you have a bar ticket. It's really not a ticket. I don't think, we just call it bar ticket, but
Yeah.
the state bar says that you're licensed to practice law.
Exactly.
The notaries have a commission that says that they can act as a notary public. What the official version is a notary public is an official of integrity appointed by the state. Well, there's a lot of words in there. What does it mean? Well, the first word that you have to look at is official. That means that they have some public standing. In this case, the Secretary of State has recognized them to do certain functions. Of integrity, they go through a background check. As long as they pass the background check, then they can, assuming that they take the course and pass the test, be appointed by the Secretary of State to act as a notary public. Unlike years past, you read a book, you go take a test, you're a notary. There's a lot more to it today.
Did that change rather recently, or?
Well, I don't know how long notaries have been around.
Okay.
But I know that within the last couple of years, I believe it was an open book examination, and today they have to go to a class and actually take a test. No open book to it.
Interesting. Thank you.
But they also are to serve as an impartial witness in performing a variety of official fraud deterrent acts relating to the signing of important documents. Now, we see them probably most often in real estate transactions. You go to the title company, and they're notarizing your signature. That's the notary act that we're most used to.
So what you're saying is that we're actually relying on them as to the integrity of the documents?
No.
Okay. I misinterpreted that.
All right. Well, first of all, again, what most people are used to is that they're there to witness your signature. And what most people look at it as is they attach a piece of paper saying that you, Bob, appeared before me, notary public, and provided sufficient proof of your identification, and I'm signing it.
Okay.
Right. That's how most people see a notary public.
Right. Right. That's how
That's
I've
about
seen it.
all most of us know about notary public. But as I indicated, they have to go through a test, and they get a commission that allows them for the next 4 years, as long as they stay in good standing, to act as a notary public. They really aren't, even though they're officials as such, as deemed by the Secretary of State, They are not really public servants as you and I look at it, where they're not working for a governmental agency typically, and all of them, although that some do. They're not really public servants, but let me rephrase that. They're public servants, but they're not public employees.
They perform a public service. Is that what you're saying?
That's another way to look at it, all right? Now, the commission allows them to do certain acts. In California, they have statewide jurisdiction. They can go pretty much anywhere in the state of California and notarize various documents. I won't say any documents because that's not true, but various documents.
See, statewide. How about out of state? Is that
No.
covered? Okay, just want to make sure. Okay.
But a lot of people, for instance, if you brought a document to me that was made in Southern California and say, this needs to be notarized, I don't have to go to Southern California to get it notarized. It can be notarized in Calaveras County.
No county limits on the jurisdiction.
Exactly, because it's statewide commission. And the role, in part, the role of the notary is to act as an impartial and disinterested witness to have you sign a particular document.
Well, I understand the thing about impartiality, but how does a notary actually deter criminal acts? Because they're just notarizing the signature. I'm kind of curious about that.
Well, fraud is a big issue today and always has been. If you went to a notary and said, my name is John Doe, and I need to sign this and get you to notarize it. And the notary says, do you have your identification? And you don't have identification, they're not going to notarize it. All right, what have they in essence done? They've stopped a fraud from occurring.
Correct.
Because you're pretending to be someone else other than who you are. All right? So in some respects, they're there to deter fraud.
Curious. Do they go beyond the driver's license?
It depends. We're going to talk about that in a little
Okay,
bit
all
more.
right.
But they have to identify who the party is. And again, if you don't have identification, you're not going to get very far. But as far as what they look at also is if somebody is being forced or intimidated into signing a document. And we're going to talk about that a little bit more, but you can think of different situations where someone is being asked to sign a document they don't really want to sign. The notary can hopefully spot that.
Something that comes right to bat is maybe elder abuse or something like that situation.
That's exactly what we're going to talk about in a bit. Now, there are really different types of notaries. For instance, if you go to a governmental agency and they may have their own notary. Now, the question often comes up is, well, I've got this contract with John Doe that I want to have notarized. Why don't I just go over here to our government agency and say, here, notarize this for me? They don't have to do that because even though they've got a statewide commission as any notary does, the public agency can limit the notarizing of documents related to that agency. Schools, same way, limited to the school district or the school. So if it has to do with the school, not a problem, they can notarize it, but if it deals with a real estate transaction, they can say no.
Interesting is distinguishing a little bit from a public service to what the service is and the public servant concept.
Right, you may have a public servant who is a notary, but they still can't do that. Now, if they have their own notary, but they happen to work for a government, then it's a different story. They may not be able to do it on government time, but they can certainly do it after hours. Now, kind of a special area are military notaries. Did you know that they existed?
I'd like to learn something about military notaries. I really would.
In essence, they can only notarize on a military base. Now, in this case, they don't have statewide jurisdiction. They can't sign notary for any other place except that one military base, and only for military personnel. So If you, as John Doe citizen, went to a military base, found a notary, they're not going to do anything for you.
It's going through my head, a military notary, is that involved the federal government commissioning it or the
No,
state?
it's still through the Secretary of State of
But
California,
it's limited to the military.
limited to the military base.
Very interesting. I hadn't known that.
And different from a regular notary commission that's good for 4 years. If a person on a military base gets a commission as a military personnel to do notaries, the next day they get orders to go elsewhere. As soon as they leave, the commission ends. Or if they're discharged, the commission ends. So their term may not be the full 4 years.
Understood, but what is the real purpose of limiting oneself for getting a military notary then, if you're going to go through the process?
If the general says you're going to be a notary, guess what?
You better be a notary.
That's right. So that's what it's for. The notary finds in certain situations that it's important to have notaries on their military base, but they are limited to that military base. Not any military base, but that military base.
So if you have a federal military base, I'm thinking National Guard.
It makes no
Difference?
does not make any difference really.
Okay.
All right. For the most part, we're talking about federal military bases, and I'm not aware of a situation, and there may be, that there's like a National Guard statewide organization, as it were, having their own notaries. They may well have, I don't know that answer. Notaries public are public notaries. They're the ones,
They offer their services to the public.
general
correct?
public.
Okay.
And one of the things that's very interesting about them, remember I said if you go on a military base and you want something notarized, they can tell you no.
Correct.
You go to the school district, ask them, they say no, and they have a right to do that. But if you go to a notary public who's in the business of notarizing documents, and it's during normal business hours, they cannot say no,
Well, I have a question about
assuming that everything is legal, of course.
Right, I have a question about that. Let's say somebody's an employee of some private business, and that person outside the business, a third person, happens to know that they're a notary and comes in. Is that person, that notary, obligated to notarize?
If their notary is a part of the business, for instance, you go to a title company, they can say, no, we only do title documents that go through our business. And that's the end of it. The rule for them may be, once you leave, you don't take the notary outside of the business, and that's the way it goes, all right? In other words, the business has some control.
Okay.
If I've got a notary in my office, during business hours, it's business-related notarizing. After hours, I don't care what they do,
Okay.
all right? So what is the most common act, you think?
Well, I'm thinking property deeds, wills, power of attorneys, durable power of health. But I don't think that needs to be notarized, is it? The durable power, you're going to give me a test here, are you?
Yes.
It does?
You've got about 70% thus far. You're still passing.
Okay, all right.
All right. Most often we see, as I indicated, is that some document is brought to a notary and they're watching you sign, and then they attach what's called an acknowledgement to that, and they sign that you appeared, supplied proper identification. They sign it, attach it, and it's through. And now we look at that as a notarized document where an impartial witness has seen your signature, and it carries some weight because they have now identified you. But if you brought a document into, whether it's a bank or real estate, where they do require notarizing, they can say no, because we don't know that that signature is valid. But the notary has looked at the identification, saw that it matches the driver's license or whatever form of identification, and said, yes, this is a valid signature. Now, one of the questions that comes up in that is, well, does a notary need to read what you're signing? What do you think?
Well, in preparing documents, I've always had the understanding that the answer to that is no, they just need to validate the signature and know what the document is, basically, generally.
I'm going to say that you're partially correct. All right. What a notary must do is to scan the document, talking about visually scanning, not photographically scanning a document, to make sure that there are no blank spaces. For instance, if the document said, Somebody will pay somebody blank number of dollars for whatever, and that's not filled out. Should the notary acknowledge the signature even though there's a blank there?
It's a good question.
Short answer is no. Because notaries cannot give legal advice, they essentially have to give the document back to the person, say, I can't complete this if this blank is here. So if the person says, well, what do I do? They can't give legal advice except to say, you need to go back to whoever prepared this document and complete the blank space, or you must complete it. That's as far as they can go.
Essentially, you're saying they see a flaw in the face of it that may not make it a valid document.
If they saw misspelling, they don't care. It's the blank areas that they scan for and look for. And that's about the extent of it. And I know in many situations where I've used a notary, and I'll go in with a 25-page document, most often, because I'm present, they don't even look at it. They just witness the signature, make sure the person understands what they're signing, that it's a will or power of attorney, but they don't look at it to see that it's complete, to see if there's any blanks. I think because certain people, like attorneys, they assume that we've got all of those blanks filled, because we don't like blanks either.
No, we don't. No, we don't. No, we don't.
All right. So what the notary is looking for is that identification. And normally we look at, the notary is looking for government-issued identification. And they're also looking for make sure that the person is willing to sign the document, one, without duress and intimidation, and whether or not there's a general awareness of the importance of the document that they are in fact signing. You mentioned elder abuse. A child brings in their father, their mother, who clearly is suffering from Alzheimer's or dementia, and said, oh, here's a document, turns out to be a deed of trust to son or daughter that brought mom or dad in, and they're signing, mom or dad is signing the house over to their child. All right? And they clearly do not understand what's going on. In that case, the notary clearly has to say that the person is not aware of what they're doing, okay, or may be subject to intimidation to sign this document, and the notary at that point should say stop.
Well, let's say the notary suspects a mental infirmity of some kind.
They can refuse to actually do the notarization.
Is there some standard, a test in that?
Personal judgment.
Common sense?
Well, for most of us, I'd say common sense. And I would think that everybody can, if you're not sure, ask another question. All right? Do you know what today is?
Who the president?
1903.
Who's the president?
There's no real test that the notary has to give. It's just a general sense. And they said, I'm not comfortable in doing this. If it's clearly a situation where they're being intimidated or they're clearly suffering from some form of dementia, the notary certainly can call law enforcement, the Adult Protective Services, there we go, APS, and report. I believe that this may be going on. Allow them to investigate it. A notary doesn't have to do any investigation, but common sense says, yes, they should report it.
I'm just curious, in the type of law that I do and we do, is there any personal liability on the notary in this area?
Absolutely. I'm not going to get into a big discussion of it. Notaries have to be bonded.
Okay.
And that's really to protect people from the bad acts of the notary. If the notary did something wrong, clearly the person that's signing document is being forced, suffering clearly from dementia, they can be sued. And that's what the bond is for, but they are still individually and personally liable. Doesn't all go against the bond. Not only civilly, but criminally. And the fines, depending on the situation, up to $10,000 per occurrence.
How would you know if a notary's bonded? Because I've been involved with a lot of notaries. I never heard anybody say, hey, excuse me, but are you bonded?
Once a notary or a person that's looking to be a notary gets their commission, their authority or right to be a notary, they've got to file it with the county clerk and show proof of bond. Without that, they're not going to go very far, okay?
So if they're operating, they're bonded.
They're going to be bonded,
Okay.
all right? Now, the level of how much of a bond they have is up to them. There are some minimums that I don't recall offhand that the state requires. Now, when we think of notary, thus far we've been essentially talking about notarizing. There are certain situations, less common, where a notary can actually notarize a document that the person who signed it is not personally present, but somebody else is saying, yes, that's John Doe's signature. We're not going to get into those. They're called jurats, far more complex, and notaries tend to slow the process down so they make sure they do everything right, because they're not frequent. But again,
I'm
it is
thinking
possible.
military service or something like that.
It could be military service, somebody's in the hospital, can't get into the notary, and somebody comes in and says, well, I saw him sign it. But again, I don't want to get into too much detail on that because that's a very unusual situation. And if they run across that situation in their own personal life, they really need to talk to a notary, find out what requirements a notary has to get that document notarized. And there are a number of steps that they have to go through. So often comes the question about the wording in here isn't correct.
Well, can they give advice about the document?
Short answer is no. Now, there are situations where a notary is also an attorney. Can the attorney then give legal advice regarding the document?
Maybe it depends on which hat he's wearing or she's wearing.
Actually, it may depend on who prepared the document.
Very good point.
If some other attorney prepared the document, does the notary/attorney want to be giving advice on what somebody else prepared?
Interfering with the attorney-client relationship.
All right. Because they're now wearing the hat of notary, short answer is no. If there is a clear issue, what do you think a notary should do?
Clear issue of
There's something wrong with the document.
legally, a legal issue, and a lawyer's looking at, well, he should refuse to
But
sign it.
he's a notary and an attorney.
I would think that he should refuse to sign it or notarize it and maybe send it back and let that other attorney address it. It would be my immediate reaction.
The notary can't say, this needs to be fixed. All right, clearly, you need to put these words in here. Because even though they're an attorney, they've got to send them back to the agency or attorney, whoever prepared it, and say that I'm seeing some issues here. I'm not going to be able to notarize this for you. Well, why? You have to discuss that with your agency or your attorney, but they can't give legal advice. Like I say, even if they're an attorney. Now, if I'm a notary, I'm an attorney, I wrote the document, and I'm notarizing my client's document, is that okay?
Yes, one would think yes. I don't see any problem with that.
You're right. And now, if there is something to be cleared up, it's my fault. I should have done it right in the first place. So I just go fix it. Then the client can sign it, and I can notarize it. Now, in that situation where I've, let's say, worked with a client for many months, created this document, I know who they are, maybe I even knew them beforehand. Do I need ID as a notary, even though I'm an attorney representing that person?
I'm going to say yes, absolutely. It's required.
And you're correct. In past days, all that was necessary was, I know who you are, I can notarize this. But a couple of years ago, I'll say a couple, it's been several years ago, that changed. Even if it's a family member who you've known your entire life, you have to get identification.
So it has to be documented.
It must be a document, yes. Okay? We get into the situation where notaries can't give legal advice, like paralegals not supposed to say, you need to do check mark here. If a person comes in and they say, I need this, a jurat on this document,
That's where they're not present.
That's
right?
where they're not present. And even if you know that that's not what they need, and they've got all of the steps for a jurat, you can't tell them as a notary, that's the wrong document. You really need this one. So if they want a jurat and the situation's right for a jurat, that's what the notary has to do. They can't say, this is all you need to do, because that's now giving legal advice.
And they're not supposed to be practicing law without a license, so you can't cross over that border.
It's a little technical, and that's why notaries have to go to school and learn how to do this, so they know what situations that they've got to be very careful in. So, we talked about the notaries reading the document. They're not going to do that. They're just going to make sure, in many instances, they may write down that you brought in a 5-page power of attorney. So if later someone says, well, I've got this 3-page one, and it's power of attorney, and your acknowledgement is attached, the notary can go back to their journal and say, no, that's not, because I notarized a 5-page power of attorney.
So they actually make the entry as to,
their-
I've often wondered that.
In their journal, and there's minimum stuff that's required to go in the journal, but in today's world, notaries tend to be a little bit more specific, more than just the date and what the document is. They'll often put and they'll put down the driver's license, it was California driver's license number, the name of the person, and they may put down a number of pages as well. So, and let me jump on ahead here real quick.
I was just going to ask about signature lines, because I see documents prepared with signature lines all the time, particularly coming from insurance companies, and then we get a notary involved and say, I'm not interested in that, let me just slap mine on. I'm kind of curious about that. That the notary usually wants to use their form.
There's very specific wording that's got to be on an acknowledgement, and if it's not there, they can't use the pre-prepared format. They've got to use one that's specifically laid out by the Secretary of State, and it's actually in the statutes in the government code what you're supposed to be in there. But that also brings up a situation where a husband and wife go in, or excuse me, a husband and a wife are to sign a document, but only one party goes in. But we've got a blank line for the wife to sign. The notary can do acknowledgement on the husband